Go on YouTube and see if you see me. Mute. Live now. Hello. Hi. Hello, hello. Good morning, good afternoon, depending where you are. I hope you have had a good week. Today is Friday. So I'm here today to give you some new updates on the public charge rule, some good news coming out of this US Supreme Court, not the bad news you've had today, but the good news of regarding the public charge. So the public charge rule, the Supreme Court has ended the challenge of the public charge rule. So you may wonder, what is public charge rule? Who does it concern? It concerns a lot of people who apply for green card benefits based on family. If you are a US citizen, or if you are a legal permanent resident and you are filing for your spouse, your parents, your children, you have to prove that you have enough income to overcome the public charge inadmissibility. So we have prepared today. My team, they did a good job, prepared a PowerPoint on this subject that I'm going to share so that you can watch with me. Okay, and again, welcome, and always follow us, subscribe, comment, like, so we can continue providing these new updates on immigration law. We know all of that we know very well that so much has been changed, so much is being reestablished or terminated, but all these challenges or these changes do not go without fight by so some of people who do not really wish for immigration to be accessible for all. So one of the rule that was put in place by the Trump administration was I guess what I would say, conditions on who can bring in a family member, how much income, what's considered a public charge. So when the Biden administration came or took over, they removed those challenges and they reestablished the public charge, or the elements to determine what is a public charge that were in place before the Trump administration. When that happened, the states, some of the states, they sued the Biden administration so that the challenges of all those heightened conditions on public charge could stay. So when those states sued the US government, the case went all the way to the Supreme Court, and the Supreme Court recently has, I mean, in a ruling, it's just one word, determined that those states have no standing in challenging or warning those high, like the conditions on the public charge rule to stay. So the government, the Biden government, has reestablished the public charge as it has been since. I guess let's look together when. So then we have a chart here. So what is the public charge rule? So the public charge is defined by. So anyway, so it's one of the conditions or inadmissibility grounds. No one can be admitted to the United States if they will be deemed to become a public charge. That's basically what you need to know. But when did that happen? Here is the historic. You can go and read. I don't want to take much of your time. So it was enacted by the Immigration Nationality Act. And but the law did not define what is a public charge. That's why when the law was established, then regulations were put in place to kind of put in place the conditions one must meet to show they have, overcome the public charge. So here's the legal history. So yes, so this the 1999 Field Guidance Regulation said that an alien who has become or likely to become primarily dependent on the federal government for subsistence will be deemed to be inadmissible. So what does constitute dependency on federal government? So it's not like anyone who seeks federal government assistance will be deemed to be a public charge. No, they specifically said, or this field guidance specifically said, those who have received public cash assistance for income to maintain or to be in a long-term care at the government expense. So in 2019, the Trump administration then issued new regulations that broadened the scope of programs that the federal government would consider in public charge. And then they issued a new form. So we had to complete a new form I-944, which is, self-sufficiency sort of, that was the form to which asks all kinds of questions. They ask you your financial situation. Do you rent a house? Do you own a house? What kind of savings do you have? They ask, do you have any insurance? They wanted to see, are you going to have insurance? When you bring someone in, are they going to have medical insurance? Do you have retirement accounts? So they wanted to look at all those, so many I guess conditions to be met before you can prove you are able to bring in a spouse, you are able to petition or sponsor a child, you are able to sponsor a parent, you are able to sponsor your loved ones. In order to get them, you have to show all of those requirements, which, for example, a medical insurance, we know very well, even all Americans do not have access to a medical insurance. You have to show this person will be able to come and work. So those were those broadened conditions that were established by the Trump administration. A new form had to be completed in addition to Form IA-64 to be able to show self-sufficiency. So then in 2021, when the Biden administration came or took over, of course, he terminated or stopped that rule, those new conditions. But then when that happened, the states sued the government, and instead, when that happened, then the Supreme Court said, okay, these are regulations, so there's nothing that was done that it's against the law. It's within the power of the executive branch to do so, to change these rules, because anyway, the Trump administration changed the rules. So what the Biden administration is doing is get back to the established guidance that has been since 1999. Okay, so on February 2024, then the Biden, February 24th, 2022, the Biden administration proposed a new public, sorry about that, a new rule, the proposed rule, because, like I think we have discussed before, when there are procedures to follow before the executive branch or the government issues a rule, they have to go through this process of proposing a rule. They have to wait for the comment period, and then the rule is established. So they follow the rules, they follow the procedure, so that no states come and sue to say they didn't follow the procedure, right? But that did not prevent the several states to sue, right? But when they did, the US Supreme Court said, you have no standing. This rule is within the executive branch's authority to make. So now, what's happening now? Like, how do you overcome the public charge in admissibility ground? So the proposed rule, I think actually it has come to effect, because right now we no longer file I-944 with the I-864 with the affidavit of support. The form I-944 is no longer a requirement. We don't have to show all your savings, or your income, or your source of revenue, your retirement assets. You don't have to show you have a medical insurance. You don't have to show none of that. You have to show the minimum requirements that were established in the instructions of Form IA-64, which is affidavit of support. So, and if somebody has been benefited from the federal government assistance, as long as you did not use cash assistance for maintenance or government-funded institutionalized long-term, like you didn't use mental care. I mean, the immigrant, the intending immigrant, this is not the US citizen, it's the intending immigrant, then you should be able to overcome the public charge rule. So basically, what does that mean is, let's say you have a what they call the food stamps. You have been on food stamps, or you have had to have a Medicaid. You are still qualified. You are not under, or you have overcome the public charge. You are not affected by the public charge because of that. If you have received cash assistance, you have received cash, or you have been under a long-term institutionalized long-term care in a mental care or nursing home on the dime of the government, then that's the case where there will be public charge rule will affect you. There are always some exceptions. There are always waivers, even if that's the case. But yeah, so this is what I was saying, that okay, so these are I hope you can see them. Remove my hair. Here. Okay. You can read. So under the proposed rule, the federal government would only consider cash assistance program, including supplemental security income, temporary assistance for needy family and state local, tribal cash assistance to pay for basic needs such as rent, food, and utility. You also consider long-term government assistance for institutionalization, including nursing home or mental health institution. So, but in general, those are really what's gonna be considered when it comes to being inadmissible based on public charge rule. So that's what I wanted to talk to you today. But the rule, we always look at some mitigating factors, like age, family status, income and resources, education and health status. So even if you have used all these assistance or these government assistance programs, there's always a way to mitigate those factors depending on what age did you use these types of assistance, or what was the family status, or what income, or were you in what was the health status? For example, if it was an emergency Medicaid, we know very well, like somebody who's at the ER or who's brought to the emergency room cannot be refused assistance. So that will not consider you inadmissible because you have used that for emergency situation, like emergency Medicaid, or if you are an elderly person, or if you're a child, and you use those programs. So there are so many factors that will be looked at. So basically, the public charge rule will not be as stringent or like it was being made, or it was during the Trump administration. So